Hello everyone, welcome to Law Minds YouTube channel. Today we are going to know about relinquishment deed and I will explain everything you need to know about registering a relinquishment deed. To know about relinquishment deeds, first let us know what are deeds. Deeds are basically a legal written document that are used to transfer movable or removable properties or assets from one person to another. These deeds is a document which is made to get the transfer of the property a legal recognition. So as this recognition can also work as an evidence or proof of the transfer whichever is made. The deed should be signed and notarized for it to get that validity to become an evidence or a proof. This proof is presented before the court while such disputes of property is made. Now, I'll give you a brief about what is relinquishment deed. A relinquishment deed is brought into the existence by the legal heirs of the inherited property which are left intestates. Now, what are intestate properties? Properties which are left without any will is known as intestate property, and any legal heirs of that intestate properties is decided by the intestate succession. Now, this deed can only be created for the relinquishment of the share by the owner of the property in favor of the other co-owner. This deed can only be created for the owners or the legal heirs of the inherited property, and no other person can be included. Now, what is a relinquishment deed? Relinquishment deed is also known as release deed. This name in itself shows its importance. Release deed means releasing a share in favor of the other person. This deed is enacted under Transfer of Property Act 1882. Relinquishment deed is a deed that can only be created by the legal heirs of the inherited property. This deed is made when one of the property owner wants to give up on their share to the other interested co-owner of the property. For example, let us take that there are three sons taking care of a property which they inherited from their father's property. Now, while two of the son lives afar from the property and one son lives nearby the ancestral property. Now, the two other sons who are living far away are facing problems to maintain their shares in that property. So, to face that cumbersome circumstances, they gave up their share of the property in the name of the third son so that the third son can take care of that property. Now, this giving up on their share in favor of the third son can be created through a relinquishment deed. This deed is only made for the immovable properties which is left without the will. This is dealt within the property of Hindu joint families. This deed can be made or cannot be made without any consideration. Now, when and who can create a relinquishment deed? As we know that there are many more legal instruments which can be made or used to transfer the property in a legal and transparent manner. With the legal validity it requires before the court. Then why is there a need of relinquishment deed? Okay, let's understand that. A relinquishment deed is a deed which is only accessible for the owners of the inherited properties. This property can be the ancestral property in which one has a right by birth, or in self acquired property of the father who died without any will. Right? Now, let us know what are the further circumstances where a relinquishment deed can be created. First is death, divorce, urgent need of funds, minor legal heir, or failure of maintenance of the property. Now, who can create a deed? Relinquishment deed. This deed can only be created by the legal heir of the inherited property. Whoever has the legal right over that property has the right to create a relinquishment deed with only the other person who has the right on that same property, who is also known as co-owner. Now, what are the objectives of relinquishment deed? The main objective of the deed is to transfer the relinquished share of one owner to the other co-owner in a legally recognized manner. This legally recognized manner is used to attain the validity a deed requires to be get recognized in front of the court of law. This deed is made to ensure the transfer of the property should be in a transparent manner and there should be no misrepresentation between the intention of the properties, so that there are no further disputes taking place between the owners of the said property. Relinquishment deed is not only a legal instrument which allows the transfer of property, but also act as an evidence to establish the transfer of title of property properly in a legal manner. Let us know what are the steps of registering a relinquishment deed. This is a very important part of registering a relinquishment deed. First step, what is the first step for registering a relinquishment deed is to draft a deed on a 100 rupees stamp paper with all the relevant information which is required to be in that deed, that is the releaser, the release, property, statement of purpose, signatures of the owners, etc. There should be no incorrect spelling or any typing errors on the draft. It should be very simple in language and all the parties involved in the deed should understand the statement of the deed properly. Now, what is step 2? Now, step 2 is after drafting the relinquishment deed, one should visit a sub registrar office in this related locality with all the parties involved in the deed with two more witnesses. Very essential part for the deed. Everyone going to the sub registrar office should carry their original and photocopies of their said identity proofs, address proofs, and passport size photographs. Now let's move on to step 3. What is step 3 is for the registration of the relinquishment deed, a nominal fee should be paid, that is of rupees 100 or 250. Step 4 is if the sub registrar or the concerned officials are satisfied when your deed is true and is satisfied by the sub registrar or the concerned officials, that deed will be registered. Now, the registered relinquishment deed will be created within a week. The parties can then visit the office to collect the papers for the further reference. In case any of the concerned parties cannot make it to the sub registrar's office due to any illness or any disability, they are required to apply to the office. Then the concerned officer can visit the premises of such party to complete the registration under the Registrations Act section 31. Now, what is the format of a relinquishment deed? The format of a relinquishment deed is shown in this picture. As everyone can see, this is basically a standard format of relinquishment of deed. Let's now further move on to how can you revoke a relinquishment deed and what is the time limit to do that. Now, the deed can be revoked by the owner if such thing has happened. Those things are if there is any misinterpretation of his or her intention in the deed, if there is any wrongfully misinterpreted intention is there, then one can revoke the said relinquishment deed. If a consent of a said party has been taken forcefully under influence, then you can revoke a relinquishment deed. Third, if the deed was based on a fraudulent or lawful act, then the relinquishment deed can be revoked. The cancellation of the deed takes place after agreement of all the concerned parties. That is, all the concerned parties involved within that deed should agree that this deed is supposed to be cancelled. If any of the beneficiaries of that deed not agrees to cancel the said deed, the aggrieved party can go to the court. The deed can be revoked till 3 years from the date of the registration of the deed. It cannot be revoked after 3 years. This is the limit of the revocation of relinquishment deed, that it can only be this can only be revoked after 3 years of the registration. After 3 years of the registration, the deed cannot be revoked by any of the owners. This is all you need to know about registering a relinquishment deed. I hope you understand it. Thank you very much.